Morning, everyone. Thank you very much for joining this session today. Just to let you know that it is being recorded, and we will circulate the slides and a recording after the session today. So welcome to the next instalment in our series of seminars called Regulate and Resolve, where we pick through common financial services regulatory issues and provide practical guidance on how to approach them. And today we're going to look at what to do when the FCA starts asking questions. Now, this session is all about the FCA's general information gathering powers. And what it doesn't cover is the FCA's investigation enforcement powers, which are altogether broader and more intrusive, as you might expect. And actually, those will be the subject of our next session, which will take place in early December. So before we begin, and for those of you who don't know us, by way of introduction, my name's Rachel McDonnell. I head up the commercial disputes practice in Norwich at Mills and Reeve. I joined from a leading London firm last year, where as well as practicing in general commercial disputes, I also had a specialism in financial services disputes, and by that I mean financial services litigation and regulatory investigations and enforcement action, which is what we're going to talk to you about today. And I'm joined by Catherine Noble.
Hi, I'm Catherine. I'm also in the Mills and Reeves dispute team, where I work on quite a broad range of matters, but one of my areas of focus is financial services, contentious regulatory matters, so I support Rachel with those.
And just before we kick off with our overview, there is a Q&A chat function at the bottom, so please do ask questions and we'll try to deal with as many as possible at the end. If we don't get to you, we'll follow up separately.
Thanks, Rachel. So the purpose of today is to cover what happens when you as a firm receive a request or a requirement notice from the FCA seeking information or documents. And essentially, we're just going to look at what you're obliged to do, what you should do, and what you can or possibly should push back on. So the starting point is that the FCA has a wide-ranging set of powers to gather information and documents, and that there are all sorts of reasons why the FCA might want to make a request. Some of those reasons are going to be quite innocuous, others will be less so. Rachel and I will always emphasise that firms need to be mindful of their regulatory obligations and ensure that they are compliant with those obligations. Equally, you should be careful when you're dealing with the FCA, because what might start as a relatively innocuous looking request can escalate, and we'll give an example of that later. Just by way of a reminder, we've got Principle 11 up on the slide there. Firms must comply with the obligations imposed by Principle 11. And I know we've spoken about it previously and what general compliance with Principle 11 looks like, but essentially it's a requirement for the firm to keep the FCA appraised of anything that it could reasonably expect notice of. And as a firm, you're required to deal openly and cooperatively with the FCA to give notice of anything that it might want. And so you have to make yourself readily available for meetings, provide access to documents, and answer questions truthfully, fully and promptly. And there is guidance about that in the FCA handbook. We've also got an excerpt from section 165 of FSMA on the slide. Excuse me. The FCA may, doesn't have to, but it may provide a written notice to an authorised person to require the provision of either specific information or specific documents, and it could also require information or documents that fall within a specific description or class. So to aid the discussion today, we're just going to look at a few commonly asked questions, and then to think about how the obligations under Principle 11 and just generally to the FCA apply in practice.
So moving on to question number 1, we haven't received any formal notice from the FCA requiring us to provide documents or answer questions. They've just sent an email request. Do we have to comply?
So this is quite a commonly asked question. The FCA, as I said, doesn't have to provide a formal notice, and you might get that request by email, typically from someone in supervision at the FCA, asking questions about an area of your business and requesting a response within a specific time frame. Now, obviously, an email isn't a statutory notice, but there are good reasons why firms should comply with that request, not least of which is that obligation to comply with Principle 11. As I mentioned, there's guidance on that and around making yourself available and providing access in the FCA handbook. It's also worth noting that this obligation extends beyond the information that's held by your firm as a regulated entity, and it can extend to the information and documents held by group members. So essentially what we're saying is that in practice, whether or not there is a formal requirement notice, firms are typically going to cooperate with any kinds of request like this from the FCA. Not to do so is going to risk breaching your regulatory obligations, and it might also set hairs running with the FCA, which you want to avoid.
Yeah, I think there's that point, isn't there, that if you're pushing back on providing information that's been requested voluntarily, the FCA is going to be wondering why, and actually providing the information is easier than setting those hairs running and triggering a train of inquiry, when actually providing the information would have been the easiest route. And I'd also add, there are sometimes good reasons why it might help to ask the FCA to compel you to provide information requested, and we'll come on to that a bit later, but it does help to assist with compliance with other obligations owed to third parties. So moving on to question 2.
My firm has received a requirement notice from the FCA. Does that mean that the firm is under investigation?
So the short answer here is that it depends on the basis of the requirement notice, but the FCA's general powers to require information under that section 165 that Catherine talked about earlier apply even where no formal investigation has been commenced. So the answer is not necessarily. There are all sorts of potentially innocuous reasons why a firm might receive a non-routine requirement notice from the FCA, and it doesn't necessarily mean, though, that it's going to be straightforward to comply. I had a matter a few years ago where a client was actually a third party, so they weren't involved in any potential wrongdoing. The FCA was investigating allegations of potential market abuse, but our clients, by reason of an acquisition of a company, held thousands of relevant documents, and the client actually ended up spending tens of thousands in legal fees complying with that request, regardless of the fact that they themselves weren't under investigation. Another example might be that the FCA is making sort of general market inquiries, and I'll come on to that a bit more detail in a moment, but the FCA's review of the market for multi-occupancy buildings insurance started with a request for information from a sample of 17 insurers and 26 brokers. So it could be a broad market inquiry as well.
Yeah, so just to kind of bring that together a little bit, what can seem like a reasonable or innocuous request can lead to further action, and one inquiry can lead to others. So just kind of bear that in mind. It's always going to remain open to the FCA to take additional steps, including the commencement of an investigation if it considers appropriate. And what those additional steps that the FCA requests is going to depend very much on the nature of the initial request, and then how the information is provided in response and how the matter develops. So it's not kind of one size fits all thing. The take-home point from this is that firms need to be alive to the risks of providing information to the FCA, and also to the basis of their obligations. So we would always say put in lots of detailed consideration at an early stage, because that reaps benefits later down the line. And also, you could say we would say this, but you really will benefit from taking early legal advice. So moving on to our next question. The FCA has issued a requirement notice seeking specified information and documents. Is there room for discussion about the scope of what is being sought?
Thanks, Catherine. So yeah, this is question number 3 on the next slide. Look, this really depends on the nature of the request. Is it something that has been issued to the market by the FCA, or is this something that's more specific to your firm? And if it's more bespoke, then perhaps there may be opportunity for more discussion. It may be possible to have a dialogue with the FCA, especially if the requests appear excessive or burdensome. If concerns have been raised, then you might want to provide additional information or explanation to address those concerns. It may be that it's difficult for the FCA to understand really the pattern of what went on without having that narrative. And I've worked on a number of matters where actually the only request has been for documents, but along with those documents, the firm decided to put in an explanation so that it could head off any questions that the FCA might have. For example, we're missing documents because, or the policy changed as a result of X, or all sorts of different ways to explain why things evolved, why things happened, and why decisions were taken, which documents themselves may well not provide on their own. And it's really about controlling the narrative and helping the FCA, but also heading off those questions.
Thanks, Rachel. Yeah, I think it's really important that you need to remember that the FCA doesn't necessarily know the firm, in fact, won't know your firm the way that you do. They're not going to know what isn't available. They're not going to know what your firm's decision-making procedures are or the driving force behind the decisions that you've made. So if you, on receipt of a request, think that there is a better or more efficient way or format to provide the information or documents that are being requested, it really can be worth asking the FCA about it, because those initial discussions can help reduce both your time and the FCA's time spent on dealing with the matter. The caveat to that is if the FCA has made a blanket request for information, then they're less likely to engage in those discussions. And on those occasions, as Rachel was saying, it's best for you to deliver up what you can as best as you can, and then provide that narrative explanation about the limitations on the information that's been available.
Okay, moving on to question number 4. Do we have to deliver absolutely everything that the FCA has requested?
So no, you don't, but, and it is a big but, firms can only withhold documents on a number of fairly limited bases. The most common of those is that the documents are privileged. So when we're talking about privileged documents, essentially we're talking about those which are subject to legal advice or litigation privilege. And under FSMA, they're known as protected items. And a person isn't required to provide the protected items to the FCA. Excuse me. As such, before you provide information to the FCA, you should do a thorough review of what is being provided to try and ensure that privileged documents aren't inadvertently being provided, or that where they are being provided, you've taken an active decision to waive privilege. The other point to note is that privilege can be lost in documents quite easily. We have discussed this previously, but essentially firms sometimes disseminate or share documents too widely, and that leads to loss of confidentiality and therefore privilege. That's just something to keep an eye on.
Thanks, Catherine. And as I alluded to earlier, there are other bases on which firms can withhold documents or information, for example, for data protection reasons or banking confidentiality obligations owed to clients. But these can often easily be overcome by the FCA, specifically requiring the information or documents disclosure. So, for example, if they are specifically for sort of names and contact details, then that data protection obligation will be overridden. From experience, I have worked with a number of clients that have asked the FCA to compel them to provide information because that will avoid a confidentiality or data protection breach. Whereas if they're asked to provide it voluntarily, they don't have that protection on confidentiality or data protection. And I think a related question to question 4 is, how extensive does that search need to be? Now, there's often going to be a proportionality aspect to the search and review, and no one, not even the FCA, expects a firm to look at every single document ever produced to consider whether it should be provided. That said, sort of a quick look is not going to cut it in the FCA's eyes. Again, it's going to depend on what has been requested, but you need to be able, if asked, and the FCA does sometimes ask, to explain and justify the steps you've taken to identify relevant documents. And anyone in the litigation process will have a fair idea of what that looks like. And that's thinking about questions such as, where might the documents be stored? Do we need to send out document preservation notices? Which people within the business are involved in the areas that have been asked about? Do we need to search for emails? And if we do, what are the date ranges and keywords that might be used to narrow down that review? Now, the matter I mentioned earlier about the investigation into market manipulation, the FCA actually requested all of the information surrounding how the relevant documents had been identified, what search terms were used, what custodians had been looked at, and our client was asked to justify the scope of that review before it delivered up the documents. And as I said, there were tens of thousands of documents. So keeping that audit trail of what has been reviewed and how is critically important, particularly, it happens, it does happen that firms later identify documents that were responsive to requirement notices and then deliver them up. If you can then say, well, actually, we thought the scope of what we'd looked at was sufficient, that then gives you the ability to say to the FCA, look, this is what we did, and we thought that was sufficient, but we have now identified further documents, as opposed to just saying to the FCA, oh, we happened upon some additional materials.
Thanks, Rachel. I think that audit trail point is a really, really good one. And I think it's also worth just remembering that the audit trail and the control over your documents can extend beyond your firm. So you do need to think about documents which are technically in your control, but are in the possession of third parties that you work with. So normally we're talking about auditors, accountants and lawyers. And essentially, if any of those hold documents that could be relevant, you need to be asking for them back if you don't also have copies of them, because they could well need to be delivered to the FCA. What we're trying to avoid is a situation where you say to the FCA that documents don't exist, and then where you have to go back and say, oops, by the way, we do have them. It's not helpful. It adds extra time and bureaucracy to your firm, but also it can lead to the FCA asking further and potentially more intrusive questions, which obviously, ideally, we would try to avoid.
Okay, so question number 5. What can the FCA do with the information once it has been provided?
So, broadly speaking, the FCA has to keep information that has been provided on a confidential basis confidential, and that is in FSMA section 348. The reason that I'm flagging the section is because if you are providing confidential information to the FCA, it never hurts to make it explicit when that information is provided that you are providing under section 348, because it just flags it to the FCA and will hopefully limit onward disclosure. The unauthorised use or disclosure of confidential information is a criminal offence. That said, there are a number of exceptions to those obligations which allow the FCA to disclose information to third parties in certain circumstances. So, for example, if the FCA is helping overseas regulators and is assisting them carrying out their functions, or if there is a investigation into criminal proceedings, that would be the kind of thing where the FCA would be able to disclose that information.
Yeah, I'd add there that there are a number of technical gateways by which the FCA is able to share information. So you shouldn't assume at all that providing the information isn't going to end up elsewhere. But it's always worth, as Catherine said, flagging that this information that you're providing is being provided under section 348 to protect yourself as best as you can. I just wanted to end by giving a bit of an example about how matters can escalate and develop. So you can see on the next slide just a bit of a flow chart there. A bit of an example, it's pretty topical as the FCA report came out only a couple of weeks ago, which was a review into insurance for multi-occupancy dwellings. Now, for those of you who aren't involved in this area, at the beginning of the year, the Secretary of State for Levelling Up asked the FCA and the Competition and Markets Authority to review the way that the market operates for multi-occupancy building insurance. As you might expect, since Grenfell, there's been a year-on-year increase in the costs of this insurance, so that between 2016 and 2021, the mean prices have increased by 125%. And actually those costs, the concern that the FCA has in particular is that those costs are being passed on to leaseholders who actually, because of the way the market operates, don't really have any control or transparency over the costs. And the FCA in particular is concerned that there are a number of different parties within the distribution chain sharing in commissions, so brokers, property managers, etc. And the leaseholders who ultimately foot the bill don't have any transparency over this. So the review sort of started with that letter from the Secretary of State and then moved to a Dear CEO letter sent by the FCA in January, with a warning that they expect people to be reviewing their products and making sure they provide fair value. It said, to help us inform our review, we're going to collect information to examine firms' approach to pricing for multi-occupancy dwellings. And that's where you see the FCA then going out to market and asking 17 insurers and 26 brokers to provide extensive information and data so that they could try to work out the causes for the rises and identify any areas of concern. Of course, in each of its communications, the FCA ends with some sort of warning that looks like, where regulated entities are not filling their regulatory responsibilities, we will use our powers to intervene. So the FCA report came out last month, a few weeks ago, and it identified a number of issues, and in particular that the level of commissions charged by brokers and the market in the area were of significant concern. So now you've got a situation where you had a Dear CEO letter, you had a request for information from the market, and among numerous other actions, you've got a multi-firm review of the brokers who are charging the highest commissions in those areas. So you can see a step up, more intrusive, an escalation and a bit of a heating up in the area. Now, what will happen following that isn't clear. Perhaps they'll take further action, perhaps they'll only be forward-looking. Someone might be made an example of, or there might be some remediation actions. But it does serve to show, and this happens across the board across all markets, that development of how something that initially can seem sort of wide-ranging, potentially innocuous, can become less so. So that was all we had on information requirements and what to do when the FCA starts asking questions. Perhaps we can pick up a couple of questions before we finish for the session for the day. I've got one question here. What if we really just don't have time or don't understand the scope and the FCA won't engage with us? And that actually does happen. That does happen relatively regularly, that the FCA isn't potentially, because they don't really know what's your business, what the issues are and what your business has decided to do and why, their questions might not quite hit the mark. So here you have a few options. You can typically conduct the searches that you can in the time you have, if the time frame is particularly difficult, and make clear in the response the limitations of your search and the basis on which the documents have been provided. So putting that into context, you could say, by asking for this, we understand that the FCA means this, or, where data isn't available, explaining that, putting the parameters around why. Typically, and this happened, I think, quite a lot in the multi-occupancy review, we don't hold that form of data because that's not the way the business is structured, or we don't use that system, etc. So there are a number of different approaches that you can take, but especially if you've been required to provide that information and the FCA isn't engaging with you about your questions, or you don't typically want to sort of go back and set hairs running with the FCA by asking further questions, you can frame your response to make sure that you've done the best you can in the time allowed. And very quickly, just one last question I see here. What happens if we don't comply with a request for information? So I guess that really depends on the basis on which the request has been made. So I think, as Catherine said earlier, if it's not a statutory requirement and it's just a request, then you potentially risk breaching regulatory obligations, i.e. Principle 11, by not complying. And that, in theory, could lead to the FCA taking further action against the firm for that breach. If, however, it's a formal statutory requirement notice, and you'll probably see this warning on the bottom of the notice, the risk of non-compliance is actually potential contempt of court, and that's imprisonment, a fine, or both. So the stakes are really particularly high where you've been required to provide that information. Okay, I think that deals with the questions. Just wanted to end by saying, thank you very much for joining us today, and we'll finish there. If you have any further questions, please do get in touch with us and let us know if there are any other topics that you'd like to see covered. We'd really appreciate your thoughts and your feedback. The next session will take place in early December, and that will be an outline of the FCA enforcement process and their powers in that context. Thanks very much for joining.